A knock at the door. An officer, notebook in hand, says, "We've had a complaint about noise coming from this address," or maybe it's about your dog, your bins, an argument a neighbor overheard, or behavior someone found upsetting. And immediately, most people do exactly what you'd expect. They get defensive, they start explaining everything at once, or they panic and assume this is somehow already a criminal matter, even though, in reality, almost nothing formal may have happened at this stage at all. Here's what almost nobody understands about this specific sentence: "We've had a complaint" is one of the vaguest, least legally precise things an officer can say to you, and it covers an enormous range of situations, from something with real legal teeth behind it, to something that amounts to almost nothing at all, and could just as easily be resolved with a 2-minute, entirely calm conversation. Knowing the difference changes how you should respond completely, and it's exactly the gap in knowledge that leads so many people to either say far more than they needed to, or react with far more hostility than the situation ever called for. I'm a solicitor here in England and Wales, and in this video I'm walking you through exactly what "we've had a complaint" actually means in law, the specific process that's supposed to happen before any formal action follows, and the calm, simple response that protects you whether the complaint is genuine, exaggerated, or coming from nowhere at all. Picture a woman at home one Sunday afternoon. Call her Lisa. There's a knock at the door. An officer explains a neighbor has complained about noise from a party the night before. In the first version of this story, Lisa is mortified and immediately over-explains, insisting it was a one-off, promising it'll never happen again, offering a detailed account of exactly who was there and what time everyone left, all in an effort to seem reasonable. None of this was required, and she's now created a detailed record of her own evening that didn't need to exist at all, over what may well have been a single, minor complaint with no formal process behind it whatsoever. In the second version, Lisa is offended at the accusation, so she becomes defensive immediately. "That's ridiculous. Nobody complained. You're making this up," and the conversation escalates. Now the officer's notes describe an uncooperative, hostile resident, and that description follows Lisa into any further stage of the process, entirely unnecessarily. Same knock, two completely opposite mistakes. Let's make sure you're neither version of Lisa. Here's the foundation. A complaint, on its own, is not a criminal charge, a formal notice, or evidence of anything. It's simply information that's come in from a member of the public, a neighbor, a passerby, someone in the area, and an officer following it up. Crucially, a single complaint very often triggers nothing more than exactly what's happening in this scenario: an informal conversation, sometimes described by police as words of advice or an informal warning. It does not automatically mean you're under investigation, and it certainly doesn't mean anything close to an arrest is coming. Understanding this from the outset changes the entire emotional temperature of the conversation. There's no need to panic, and equally, no need to become defensive, because in the vast majority of cases, nothing formal has actually happened yet at all. That said, complaints about ongoing nuisance behavior, persistent noise, an uncontrolled dog, rubbish, or similar issues can, if they continue, lead to something with genuine legal force. A community protection notice introduced under Section 43 of the Antisocial Behavior, Crime and Policing Act 2014 Here's the part that matters most. A formal community protection notice cannot simply be issued out of nowhere, on the strength of a single complaint, with no warning. The law requires that, before a formal notice can be given, the person responsible must first be given a written warning making clear what behavior needs to stop or change, and giving a reasonable opportunity to address it before anything formal follows. Only if the behavior continues after that warning can an actual community protection notice be issued, and only then does breaching it become a genuine criminal offense, carrying a fine. This staged approach exists precisely so that people aren't hit with formal, court-enforceable notices out of nowhere, without ever having had a genuine chance to change their behavior first. It reflects a broader principle running through this entire area of the law, that proportionate, informal engagement should always come first, with formal enforcement reserved for situations where that informal stage has genuinely been tried and hasn't worked. So if an officer arrives at your door mentioning a complaint for what sounds like the first time, you are almost certainly nowhere near this formal stage yet. Knowing this distinction between an informal first conversation and an actual, legally binding notice is exactly what stops people panicking into over-explaining everything on the doorstep. Noise complaints are probably the single most common version of this scenario, so it's worth understanding the specific legal backdrop. Under Section 5 of the Public Order Act 1986 causing harassment, alarm, or distress through disorderly behaviour, which can include excessive noise in some circumstances, is an offence, but it requires a genuine, specific threshold to be met, not simply the music was on. It's also worth knowing that if you're indoors, and you had no reason to believe your noise could be heard outside your own property, that can be a relevant defence to this kind of allegation. This is exactly why the general nature of the complaint matters, and why it's reasonable to ask what specifically has been reported before responding in detail. Separately from police involvement, persistent noise nuisance can also be raised with your local council's environmental health team, who have their own separate powers under different legislation. If police mention a noise complaint, it's worth knowing whether this is genuinely a police matter at all, or whether it's actually something more appropriately handled through the council, and it's entirely reasonable to ask which route is actually being followed. Sometimes a complaint doesn't relate to a single incident at all, but to an ongoing dispute between neighbours, ongoing tension, repeated friction, ongoing allegations from both sides. In more serious, persistent cases, police or a local authority can apply for a civil injunction under the same 2014 Act, designed to prevent behaviour that's causing, or is likely to cause, harassment, alarm, or distress. This is a genuinely more significant step than an informal doorstep conversation, and it involves a proper court process, with an opportunity to respond and be heard, rather than something imposed on the spot. If you find yourself in a genuinely ongoing dispute with a neighbour, and complaints keep being made, it's worth understanding early that this can escalate through recognised, structured legal stages, informal warning, formal notice, and ultimately, in the most serious or persistent cases, injunction proceedings, rather than assuming every single complaint exists in isolation with no connection to what came before. This happens more than people realize, a misunderstanding, a one-sided account, or occasionally, a neighbor or acquaintance making something up entirely out of spite. Here's the important thing to know: a complaint being made does not mean it's automatically believed or acted upon. Officers are generally expected to assess the credibility of what they've been told, not simply repeat it as established fact. If you genuinely believe a complaint against you is exaggerated or entirely false, the doorstep conversation is not the moment to launch into a detailed rebuttal or a counter-accusation about the person who complained. As we've covered throughout this channel, that impulse to over-explain almost always creates more material than it resolves. A calm, measured response protects you far better than an emotional one. And if the situation continues or escalates, that's exactly the point at which proper advice becomes valuable, not the first doorstep conversation. It's also worth recognizing that a single false or exaggerated complaint, on its own, very rarely leads anywhere formal. The staged process we've already discussed: informal warning, then written warning, then a formal notice only if the underlying behavior genuinely continues, provides its own natural protection against one-off, unreliable complaints escalating into something serious. This is exactly why staying calm at this early stage matters so much. The system itself is built to require repeated, substantiated concern before real consequences follow, not a single account from one dissatisfied neighbor. Here's a version of this topic that gets far less attention, but genuinely matters. What if you're the person who's been repeatedly complaining about a persistently noisy neighbor, ongoing harassment, or a problem that simply won't stop, and you feel like nothing is being done? This is exactly the situation the ASB case review formerly known as the community trigger exists for. Under the Antisocial Behaviour, Crime and Policing Act 2014, if you've reported the same problem a set number of times within a recent period, commonly 3 times within 6 months, though the exact local threshold can vary slightly by area, without adequate action being taken, you're entitled to formally request a multi-agency case review. This brings together police, the council, and other relevant bodies to properly reassess the situation and consider what further action might genuinely help. If you're on the receiving end of ongoing antisocial behavior and feel like your complaints are going nowhere, this formal review process is worth knowing about and actively requesting. It exists specifically because persistent problems were, for a long time, falling through the cracks between different agencies with none of them taking full ownership. To request a review, you generally contact your local council or police force directly and ask for an ASB case review, sometimes still listed under its older name on local websites. Keep a simple log of each time you've reported the issue. including dates and reference numbers where you're given them, since this record is exactly what demonstrates you've met the reporting threshold and strengthens the case for a genuine multi-agency response. Whichever side of this situation you're on, there's one calm, simple question that does more work than anything else, right at the start of the conversation. Can you tell me, in general terms, what the complaint relates to, and whether this is an informal conversation or something more formal? This does an enormous amount of work in a single sentence. It establishes whether you're dealing with a first, informal conversation, the vast majority of these situations, or something that's already progressed further, like a formal warning connected to a community protection notice process. It also signals, calmly and without hostility, that you understand there's a real difference between the two, which tends to shift the entire tone of the conversation toward something more measured and proportionate. Let's make this practical. Step 1. Establish the nature of the conversation. Is this the first time this has been raised, or has there been a previous warning? This tells you immediately where you stand in the process. Step 2. Acknowledge without over-explaining. You can be calm and cooperative without narrating every detail of the evening or incident in question. I understand, and I'll be mindful of that going forward. Step 3. If you disagree with the substance of the complaint, say so briefly, without a lengthy rebuttal. I don't believe that's an accurate account, but I'm happy to be mindful of the concern raised. You're not obliged to prove your innocence on the doorstep, particularly for something that, at this stage, is very likely still entirely informal. Step 4. If this is clearly progressing toward something formal, take it seriously and consider advice. If an officer specifically mentions a written warning, a community protection notice, or the possibility of further formal action, that's the moment to say, I'd like to take this seriously, could I have that in writing, and I'll consider getting advice on it. A few things worth avoiding. Mistake 1. Treating an informal chat as a criminal interview. Panicking as though a doorstep mention of a complaint is equivalent to a formal police interview under caution creates unnecessary stress, and often leads to oversharing that wasn't remotely required at this early, informal stage. Mistake 2. Becoming hostile toward the officer, or toward the person who complained. It's understandable to feel frustrated, especially if a complaint feels unfair, but hostility toward the officer gets recorded and can shape how future interactions go, and reacting angrily toward whoever made the complaint, especially if it's a neighbor, can turn a minor, resolvable issue into a genuinely ongoing dispute that ends up needing the civil injunction process we discussed earlier. Mistake 3. Ignoring a genuine formal warning. On the flip side, if a conversation has clearly moved beyond the informal stage, a written warning has actually been issued, or there's mention of a community protection notice, treating it as no big deal and continuing exactly as before is how people end up facing a genuine fine or further formal action that could otherwise have been avoided. Mistake 4. Not knowing you can challenge a formal notice. If a community protection notice genuinely is issued, you have the right to appeal it to a magistrate's court within a set time limit, generally 21 days. A lot of people don't realize this route exists, and simply accept a notice they believe was wrongly issued, when a proper legal challenge might well have succeeded, given the strict timeframe involved. If you're ever handed a formal notice you genuinely disagree with, treat the clock as already running from the moment you receive it, rather than assuming there's ample time to decide what to do later. It's worth mentioning one more variation of this scenario, because it comes up more often than people expect: complaints connected to a business you run, or your conduct in a professional setting, rather than your home life. This might be a complaint about noise from commercial premises, a dispute with a customer that's escalated, or a workplace incident someone has reported. The same underlying principles still apply. A single complaint rarely means formal action is imminent, and the informal warning before formal notice structure we've covered generally still holds for business premises facing something like a community protection notice. However, businesses can face additional regulatory routes depending on the nature of the complaint. Environmental health, licensing conditions, or trading standards may become involved alongside, or instead of, the police, depending on exactly what's being raised. If a complaint touches on your business specifically, it's worth asking directly which body is actually leading on the matter. since police involvement doesn't necessarily mean every other regulatory process is automatically in motion as well, and vice versa. Whatever the outcome of the initial conversation, it's worth developing a simple habit: keep a brief, factual note of what was actually said, by both sides, as soon as reasonably possible afterwards. Not a dramatic account, not a defensive justification, just the basics. The date, roughly what was raised, whether it was described as informal or formal, and the name or collar number of the officer if you have it. This matters for two reasons. First, if the situation does progress, a second complaint arrives. A written warning follows. Having an accurate record of exactly what happened at the first stage makes it far easier to show a genuine, proportionate response on your part, rather than relying on memory alone months later. Second, if you ever do need to challenge a formal notice at a magistrate's court, that early, contemporaneous record can be genuinely useful evidence of how reasonably you responded from the very beginning, rather than only from the point things became formal. Here's how this should actually play out. An officer mentions a complaint. You ask calmly whether this is informal or something more formal. If it's clearly the former, the vast majority of cases, you acknowledge it briefly, without over-explaining or becoming defensive, and move on with your day. If it's progressed further, an actual written warning, or mention of a formal notice, you take it seriously. Ask for details in writing, and consider proper advice before it develops any further. And if you're the person who's been complaining without results, you know that a formal case review process exists specifically for exactly that situation. Let's bring it all together. Remember that "we've had a complaint" is often the vaguest, least formal thing an officer can say, and in most cases, it means nothing more than an informal conversation, not a criminal investigation. Remember the real legal process behind persistent issues: a written warning first. Then, only if that's ignored, a formal community protection notice under Section 43 of the Antisocial Behaviour, Crime and Policing Act 2014, with a genuine right to appeal to a magistrate's court within 21 days if you believe it was wrongly issued. Remember that noise specifically has its own legal threshold under Section 5 of the Public Order Act 1986, and that persistent neighbour disputes can, in serious cases, lead to a formal civil injunction through the courts. Remember the simple phrase, asking calmly whether this is informal or something more formal tells you exactly where you stand, in one sentence. And remember, if you're the one who's been complaining repeatedly with no result, the ASB case review, the old community trigger, exists specifically to make sure persistent problems don't simply fall through the cracks. Because here's the truth underneath all of it. In that moment on the doorstep, most of the stress people feel comes from assuming the worst about a single, vague sentence. The moment you understand that a complaint is simply information, and that there's a real, structured legal process that has to happen before anything formal follows, the entire conversation becomes far easier to navigate calmly. That understanding doesn't just protect you if you're the person a complaint has been made about. It equally empowers you if you're the one who's been raising concerns and feels like nobody is listening. Because the same legal structure that protects people from overreaction also guarantees a genuine route to escalation when a problem is real and ongoing. Know your rights, because the people who know them are the ones who handle these moments with the least stress and the best outcomes, whichever side of the complaint they happen to be on. I'll see you in the next one. Asterisk disclaimer: this video is for general information only and does not constitute legal advice. Every situation is different. If you're facing a specific case, speak to a qualified solicitor as soon as possible. Asterisk.